here in a second. And with that, I'm going to turn it over to Laura and Stephanie. Thank you again for being here.
Thanks, Steph. I'm Laura Jessic. I'm MCASA's Sexual Assault Kit Initiative and Sexual Assault Response Team Program Manager. And I'm going to be presenting today with Stephanie Breen. So Stephanie, I'll allow you to introduce yourself.
Hi, everyone. I'm Stephanie Breen, and I am Solly's school policy attorney.
So as Stephanie Erdis said, we'll be presenting on sexual assault forensic exams, or SAFEs, rights, options, and new laws. I do want to note that at the beginning, we will go over some of what survivors can expect when receiving a sexual assault forensic exam. I am not a forensic nurse examiner, but we do have some lovely, I think, forensic nurse examiners who have joined us today. So if you have any other questions specific to whether it's the SAFE program nearest you or your campus, or a question specifically for a forensic nurse examiner, I will be happy to connect you to one of our forensic nurse examiners in the state, or ideally, specifically, the program that is closest to you or your campus. So with that being said, I want to get started by noting that after a sexual assault, there are many different types of care that a survivor may need. These care needs can range from seeking legal support services, whether that's asking to learn more about their legal options, or if someone is considering initiating a criminal investigation, they may be looking for some of those legal support options. Someone may also be seeking advocacy services, which can crisis intervention to hospital accompaniment, or helping address things like safety and planning. Safety planning can be a broad range of things, ranging from addressing housing needs, considering the safety of close family members like children, or addressing mental health needs, which is when crisis intervention may be in need, or long-term therapeutic counseling. Forensic medical care, which is often referred to as a sexual assault forensic exam, or SAFE for short, is also available after someone experiences a sexual assault. This is a medical exam during which the survivor is evaluated for any medical needs, such as treatment for injury, evaluation for any prophylaxis treatment like STI prevention, pregnancy prevention, or HIV prophylaxis. And a trained forensic nurse examiner will also collect any potential evidence. While the needs of each survivor after a sexual assault vary, and we want to recognize that the needs of each survivor in the aftermath of a sexual assault vary, and each are incredibly important to the survivor and unique to the survivor, we're going to be focusing today on that sexual assault forensic exam component. So a sexual assault forensic exam is conducted by a trained forensic nurse examiner. These are nurses that are experienced in the field of evidence collection and providing that medical care. They complete extensive specialized training that, again, focuses on collecting evidence, being trauma-informed, and other specific topics, maybe like human trafficking or non-fatal strangulation and drug-facilitated sexual assault. In Maryland, these exams are free to individuals that have experienced a sexual assault, and individuals can receive these exams up to 15 days after the sexual assault occurs. I also want to emphasize that a survivor looking to have a sexual assault forensic exam is not required to speak with law enforcement. So they can have the exam without reporting to police and having their identifying information remain anonymous. These are considered anonymous exams, or sometimes referred to as Jane Doe exams or blind reports. For the sake of consistency throughout today's presentation, we'll be referring to those exams as anonymous exams. So when someone goes to a hospital to receive a sexual assault forensic exam, They have three options. The first option I'm going to highlight is a medical exam only. So with this option, there is no police involvement and any potential evidence of the assault will not be collected. However, the survivor's needs for medical attention, maybe prophylaxis, any necessary STI testing will be considered and provided. And a victim advocate should still be offered to provide support during the medical exam process. Additionally, additional referrals for support services will be made for counseling or crisis intervention as always. So if somebody chooses this option, a survivor should expect a complete medical exam, probably a consultation with an FNE to make sure that they are not looking for evidence collection, medication to prevent those pregnancy, STI, and possibly HIV if applicable. And it's important to note that for this option, there's no guarantee that the exam will be covered by the state. Because there is no evidence collected of a potential crime, it may not be reimbursed, and therefore a survivor's insurance may be charged. So it's really important to keep that in mind. The second option is a medical forensic exam with reporting to law enforcement. So for this option, the survivor is choosing to report to law enforcement, and they will likely have to or be requested to meet and speak with law enforcement pretty quickly. Either before or after the exam. The survivor will receive that sexual assault forensic exam, including the medical components for injuries and assessment, as well as the evidence collection. A lot of this part of this exam is the same as I noted during the medical only exam. So an individual can expect to be assessed for any injury, receive a full physical examination, given any medication or prophylaxis necessary. There's the additional component of evidence collection and also an understanding that the evidence will be provided to the police within the next 30 days. Their evidence will then be considered for completion of DNA testing and analysis, and the individual should expect communication from the police, the victim advocate, and possibly with the state's attorney's office. And then the third option is a medical forensic exam anonymous. So like I said, this is the type of exam where a survivor is not immediately reporting to police. This allows the survivor to still have potential evidence of the crime collected from their body, but they are not required to speak to the police immediately. Their evidence will still be turned over to the police within 30 days, but no identifiable information will be available to that law enforcement agency, excuse me. The kit will be stored for the statutory requirement, which is currently a minimum of 20 years. On October 1st, that'll change to a minimum of 75 years. A survivor who chooses this anonymous exam will then be able to report to the for criminal investigation at any period of time during that 20-year, 75-year period. So briefly, I want to go over some components survivors should expect, or components of the exam that survivors should expect when reporting to a hospital for an exam. So it's important to note that these components are all optional to the survivor. Typically, a forensic nurse will go over what each component will entail, and the survivor can consent to having all of this completed, some of these completed, or they could consent and then withdraw their consent at some point during the exam. So really, it's about choice and what the survivor is comfortable with. So some of these are very, I think, standard for a medical examination. In particular, a survivor can expect to go over their medical history, so the nurse can be aware of anything they're looking for when doing a physical assessment. The assault history is when a survivor will need to go over what events took place during the assault. This can be pretty difficult for a survivor and re-traumatizing to recall that information. but it's very critical because it will guide the nurse in how to collect evidence. So, for example, if a survivor indicates that they were orally assaulted during the assault history, the nurse will know that they need to collect evidence from the mouth versus maybe the cervix. So the assault history is very critical. There's also that a physical examination for injury and any medical care and treatment. And photographs will be taken of the body and or genitals, depending again on that assault history and what took place during the assault. Additionally, again, based on that assault history or narrative, a nurse may suggest that toxicology testing may be necessary. So there are certain indicators a trained forensic nurse examiner will be looking at to determine if possible drug or alcohol facilitation was involved. This may be looking at memory loss or loss of coordination, snapshot memories where somebody may be able to remember portions of the night, but not all of it. The forensic nurse is trained to identify those possible indicators, and then urine and or blood may be collected. Lastly, of course, you have the collection of evidence. This is going to, again, vary based on the narrative of the assault and what took place, but the nurses are very well experienced and trained on identifying where potential evidence may be located and where they need to focus their collection. Next, I want to briefly touch on safe accessibility. So safes are available at designated hospitals across the state of Maryland. Not every hospital will be able to provide a survivor with a sexual assault forensic exam. So it's important to be aware of what hospitals can address this and what what hospitals may not be able to have this service available. So you can scan the QR code on your screen if you're interested in seeing where hospitals are located throughout the state that have a SAFE program, and you can navigate to our website to see this information as well. When considering getting a sexual assault forensic exam, again, I just want to note, not all hospitals have a SAFE program. However, all hospitals should have a protocol in place to ensure that the survivor is given the information and properly referred to the appropriate and nearest facility that can meet their needs. Not all SAFE programs have 24/7 coverage. This is an unfortunate side effect of just a nursing shortage throughout Maryland and throughout the country right now. So we do recommend that you take a look at our website and possibly call your nearest SAFE program before reporting for an exam to make sure that they have 24/7 coverage, or when the best time would be to go for an exam. Lastly, I just want to note that sexual assault forensic exams should be a priority. If a survivor doesn't want one, they do not need to have one, but definitely all survivors should be explained that they should be able to have access to this important forensic medical care. And I also want to note that law enforcement cannot serve as gatekeepers to safes. So for example, law enforcement can't determine that a survivor isn't, quote, eligible for a sexual assault forensic exam, or they're not, quote unquote, authorizing a sexual assault forensic exam. It is up to the survivor and the forensic nurse examiner to determine the best course of action for forensic medical care, of course, with the survivor's requests and needs as a priority. I did note that I had a question in the Q&A. So the question was, are options 2 and 3 free? So I'm assuming, and I'm going to go back, I apologize, but I'm assuming you're referring to the options of medical forensic exam with reporting to law enforcement and medical forensic exam anonymous exams. Both of these are reimbursed by the state. A survivor should never be charged or billed for the sexual assault forensic exam, as long as that forensic evidence component is part of it. So again, not just the medical exam only. I do want to note that for the medical forensic exams, again, with reporting to law enforcement and the anonymous, any treatment that is given that is not to the assault, not going to be free. So for example, if someone comes in and they note that they have high blood pressure and they've had a history of high blood pressure, they're on high blood pressure medication and the hospital deems that some treatment is needed, that's not necessarily related to the sexual assault itself, and the patient may be charged. But if somebody comes in with a head injury or a broken arm because as a result of the assault, the medical care and treatment will be reimbursed by the state. I also see a question on the difference between an FNEA and an FNEP. So if you're looking at our SAFE exam list on our website, again, the QR code is here, you will see that the list indicates FNEA, FNEP programs. Some have both, some have one. So FNEA is at forensic nurse examiners, adult and adolescent trained and certified nurses. So these are nurses that can provide exams to adults and adolescents. And then FNEP, or forensic nurse examiner pediatrics, is nurses that are specially trained to provide exams to children. So in the medical field, we're actually looking at the age of 13, not 18, like we think of legal age. So pediatric nurses can provide exams to children under the age of 13, while FNEAs provide exams to 13 and over. So be aware of that when you're looking at what SAFE program may be best for your circumstances or a survivor you may be working with. So I'm going to go ahead and hand it over to.
Thank you, Laura. Sorry about that. Thank you, Laura. So I'm going to talk a little bit about the laws surrounding sexual assault evidence kits and the new legislation that is going to be going into effect on October 1st. So the evidence that's collected during a SAFE exam is referred to as a sexual assault evidence kit, or a SAEK, and they're more commonly known as rape kits. So during the 2023 legislative session, a definition for SAEKs was included in House Bill 758 and Senate Bill 789, and it will be codified in Criminal Procedure Section 11-926. This legislation defines a sexual assault evidence kit as any physical evidence that is collected after an allegation or suspicion of sexual assault is made for the purpose of preserving that physical evidence. And like Laura just discussed, physical evidence can include a lot of things such as blood, semen, hairs, or fibers. To meet the definition of a SAEK, the evidence must be collected by a qualified healthcare provider, such as a forensic nurse examiner. And the evidence must be collected directly from the body or clothing of the person, whether living or deceased. It's also very important to note that the legislation explicitly states that sexual assault evidence kits do not include self-administered sexual assault evidence collection kits. So these kits are also being referred to as DIY kits, and Laura's going to talk about those more in depth later in the presentation. And Laura, do you mind bringing up the rest of the material for this slide? Okay, great. Oh, sorry about that. It was there, I'm sorry. Okay. So moving on, the fact that this new legislation includes a definition of SAEK kits is very important. And it has very significant implications in regard to what's going to happen with SAEKs once the evidence is collected from the survivor. So if evidence collected from a survivor meets the definition of a SAEK, then certain requirements are imposed related to kit testing, tracking, retention, and survivor rights. According to Code of Maryland Regulations 2.08.01.04, hospitals must notify the appropriate law enforcement agency of their possession of a SAEK within 30 days of collecting the evidence. And then law enforcement is required, once they're notified, to promptly send a representative to collect the kit. And unless there's an exception that applies, which I will discuss later, law enforcement must submit kits to a forensic laboratory for DNA analysis within 30 days of receiving the kit. So once forensic labs have the kits, then they should try to complete testing in a timely manner. Prior to 2017, there were no standards for when a kit could be destroyed. And what this often meant was that untested kits were just destroyed before survivors received any information about what was collected. In 2017, a bill was passed that changed this. So first, it created the first statewide retention requirement for SAKEs in Maryland. Prior to the legislation, all law enforcement agencies had varying retention periods for SAKEs. So for example, if you look at the statewide inventory of untested kits, you'll notice that Montgomery County has one of the largest inventories of any county. However, Montgomery County PD has always maintained a policy of not destroying kits, and that's why that inventory is so much higher. At the same time, other agencies in the state have had policies that may have been as short as 1 to 2 years of storage. The legislation in 2017 also imposed a requirement that kits be retained for a minimum of 20 years. Even newer legislation, which is going to go into effect on October 1st, further increases this period to 75 years. And this is critical because currently we have untested kits in Maryland that can date back to the 80s, which definitely exceeds that 20-year requirement. So that will help to ensure that those are not destroyed. In addition, the 2017 legislation included very narrow exemptions to the retention requirements. So in fact, there's only 2 scenarios in which a kit may be destroyed prior to the 20-year mark, which again will soon be the 75-year mark. So these 2 exemptions are outlined in Maryland Criminal Procedure 11-9263. And they are 1, the case for which the evidence was collected resulted in a conviction and that sentence has been completed, or all suspects that were identified by testing the kit are already deceased. It's important to note that these exemptions require either a conviction and a sentence completion, or that the kit be tested and all suspects identified through testing are deceased. So this means that if law enforcement discovers that a suspect is deceased, they cannot destroy the kit without first testing it. And all of these requirements really emphasize the fact that Maryland is placing high importance on storing and testing these kits. So next I'm going to talk about survivor rights, but before I really dig into that, I want to remind everyone that survivors have the right to an anonymous exam and to report the assault at a later date if they so choose. So kits that are collected in an anonymous exam will not be sent for testing until the survivor chooses to report the assault to law enforcement. Some states do have systems that will allow for the testing of anonymous kits, but at this time, Maryland unfortunately does not. In addition, all anonymous kits are retained per statutory requirements, which again is currently 20 years, but will soon change to 75. And a survivor can choose to report the assault to law enforcement at any time during that retention period. So there's no pressure on a survivor to report it immediately. And lastly, survivors that report the assault to police also have the right to decline forensic testing of their kit. This means that a survivor can report the assault, and at some point they can request that the investigation stop or that the scope of the investigation be limited. And this may mean that they no longer want their kit to be tested. The survivor's decision to decline analysis of their kit is one of the exemptions to testing. Now, survivors have the right to information about their kit, and they have a number of rights, which include the right to know if their kit is being tested or not, the right to know the status of testing, the right to know the results of testing, the right to be informed prior to kit destruction, the right to request an extended retention period for a kit, which in other words is delayed destruction of the kit, and the right to request a review of law enforcement agencies' decision not to test a kit. And there are some important details that we would like to highlight. So law enforcement does not have to provide status updates on kit testing if it would hinder an investigation. Upon request for a status update on a SAEK, law enforcement has 30 days to provide that information to the survivor. And requests for a review of a decision to not test a kit must be submitted in writing to the local sexual assault response team. Untested kit reviews are conducted by the local SART, and it requires that participants from various disciplines participate in the review process. So the participants include local law enforcement, local forensic nurse examiners, or another qualified healthcare provider, a rape crisis center representative, a representative from the state's attorney's office, and a representative from MCASA. SART should also endeavor to include a crime victims' rights attorney and crime lab personnel. So the cross-section of these disciplines allows for a very unique review of the case that can bring insights that were previously not considered. And review should be conducted with the state's testing criteria in mind. And if a survivor does not agree with the SART's decision, they do have the right to request a second review by the state sexual assault evidence kit policy and funding committee. It should be noted that any determination a SART or the SAEK committee makes during an untested kit review is a recommendation, and law enforcement agencies are not obligated to adhere to it. However, law enforcement does have the obligation to report to the Office of the Attorney General on the number of reviews that are conducted each year, how many of those reviews resulted in a testing recommendation, and how many of those kits were actually tested. And information about all of these rights should always be provided to a survivor at the time that a SAFE is conducted or by an advocate or detective. MCASA does have a brochure that outlines these rights in a clear question and answer format, and they are available for free for any service providers that are looking to provide them to their clients. So I'm on slide 12, survivor rights regarding the waivers that law enforcement is not able to have clients sign. So just as a reminder, many of you may already be aware that as of 2020, law enforcement agencies are prohibited from using waivers of investigation. And this law is codified in Maryland Criminal Procedure 11-929B. If a survivor requests that an investigation stop or that the scope of the investigation be limited, such as declining consent for a SAEK analysis, there is guidance on how law enforcement agencies should document this request without using a waiver. Law enforcement cannot have a survivor sign away any of law enforcement's obligations to the victim, defining or precluding the scope of the investigation, preventing or limiting prosecution, or limiting a survivor's private right of action. Okay. So I talked about this a little bit, but I want to note that information about survivors' rights should always be provided to the survivor in writing at the time of the SAFE. So it can't just be oral, it must be in writing. And this is a statutory and a regulatory requirement for healthcare providers. This requirement is codified in Maryland Criminal Procedure 11-926B2 and the Code of Maryland Regulations 2.08.01.03. As I said, advocates and detectives can also provide that information. And our brochure is shown on the right side of this screen, and you can see the formatting with the question and answer style. Prior to 2020, survivors did not have clear rights over their SAEK and the evidence included in the SAEK. So oftentimes survivors would never learn if their kit was tested. They'd never learn the results of the testing or if their kit was destroyed. In fact, a brave survivor testified about an experience she had where she was assaulted by a stranger in the early 2000s, and her ongoing attempts to contact detectives to learn about the status of her kit went unanswered. And finally, it wasn't until 2 years after she had been assaulted, someone finally returned her call, and it was just to let her know that her kit had been destroyed. So it's very important that survivors and their advocates understand the rights that survivors have. And survivors have many rights to the information about their kits. They have the right to know if their kit is being tested or not. They have the right to know the status of testing, and they have the right to know the results of testing. And it's important to note that law enforcement must provide all available results of the kit analysis, except results that would impede or compromise an ongoing investigation. And upon request for a status update on a kit, law enforcement has 30 days to provide that information. Okay, and this slide again is just referring to law enforcement's decision not to send a kit for testing, which we've already discussed. The process for law enforcement's decision not to send a kit for testing is codified in the code of the Maryland Code of Regulations at 2.08.03. So survivors have the right to request that they be notified prior to the destruction of their kit. And they can also request an extension of the time period that their kit is retained. In order to make such a request, the survivor must put it in writing to the appropriate law enforcement agency at least 60 days prior to the date of destruction of their kit. And survivors may request extensions of the retention period. Those requests can be up to 12 months or any time period that they may agree upon with law enforcement. And finally, survivors have the right, oh, I'm sorry. Oh, that was it. And so I'll go ahead and pass it back to Laura.
Thanks, Stephanie. So there's also some questions in the Q&A. I don't know if you want to touch on them now, but we had a question of, does a kit still need to be tested if it is learned that the victim is now deceased? And it's my understanding that there is no testing exemption for the victim being deceased. It's just if there's just an exemption to storing the kit for the required period of time the suspect is deceased.
That's my understanding as well. There's nothing that I've seen in the regulations that discusses the status of a victim as being deceased. But in the definition of a sexual assault evidence kit, it's physical evidence from the body of a survivor, whether alive or deceased. So because they're including deceased survivors in that definition, my understanding is that law enforcement, or that the kids are still required to be tested for deceased survivors.
Great. And then what are the statute of limitations on sexual assault cases in Maryland?
Let me get back to you with that answer by the end of the presentation. I just want to make sure I have it certain.
Sure, no problem. And then we also have the question of what would be a reason that law enforcement decides not to test a kit. And we're actually going to get into that in just a couple of slides. So thank you. All right. So before we move into, I feel like a couple of slides were missing or something. I don't know if you felt like that too, Stephanie, but we'll find out.
Yeah, for some reason they got a little out of order or something. So I'm sorry about that with a few of the like jumbled
Yeah,
slides.
just let me know if there's anything you would like me to circle back to. But in the meantime, we'll move on to the self-administered kits that we discussed or mentioned briefly at the beginning of the presentation. These self-administered kits, which are sometimes called DIY kits or at-home rape kits, or I think the legislation, the bill that passed calls it self-administered collection kits, are a controversial product that was originally introduced in 2019 prior to the COVID pandemic. And it seemed that during the height of the pandemic, the idea of these kits kind of dwindled significantly, but there's been a recent resurgence in the discussion of the use of these kits. So these kits would essentially allow survivors of sexual assault to collect evidence in their own home, potentially by themselves, or possibly with the support of a nurse present via a video call or telehealth call. The kits come with swabs and instructions for self-swabbing a variety of areas on the body, dependent on, again, what happened during the assault. One company even takes this further and states that it allows survivors to submit their DIY kit to a forensic lab for testing for potential DNA. So that's the analysis of the kit, of the evidence in the kit. The testing results from that analysis can then be provided to the survivor. In an effort to learn more about these kits and ensure that consumers and survivors are properly educated on their use in Maryland, the bill that passed in 2023, again, that's HB 758 and SB 789, address these kits in several ways. It noted, as Stephanie said earlier, that self-administered kits are not considered sexual assault evidence kits per the statutory definition. If a survivor uses a self-administered kit, it should be transferred to law enforcement, retained, and weighed for use in a criminal investigation or prosecution. There are no requirements around testing or requirements around the tracking of that kit within the chain of custody, but it should be retained by law enforcement and weighed for its use in investigation or prosecution. The bill also instructs the State Sexual Assault Evidence Kit Policy and Funding Committee and the Office of the Attorney General Consumer Protection Division to look into these kits and issue recommendations regarding the use of them in Maryland and recommendations for educating consumers and identifying other resources for survivors of sexual assault. These recommendations are due to the governor and the General Assembly on December 1st, 2023. So to be clear, no recommendations have been issued by the Sexual Assault Evidence Kit Committee or the Office of the Attorney General Consumer Protection Division to date. We want to note there are a few key differences between self-administered kits or DIY kits in a kit provided by a forensic nurse examiner at a sexual assault forensic exam program in a Maryland hospital. So to start us off, safes are free in Maryland when evidence is being collected. So as I said earlier, if somebody chooses the medical only exam, it's possible the survivor will be charged or the insurance will be charged. DIY kits, in contrast, have a cost. They are not free, and they also do not provide free treatment for injury or free treatment for prophylaxis or STI testing. If a survivor were to use one of these kits at home and they wanted STI testing or HIV prophylaxis or pregnancy prevention, they may need someone like their doctor or health department or Planned Parenthood to receive the access to that. Safes also allow forensic nurses who are very trained on identifying things like non-fatal strangulation, human trafficking, and conducting lethality assessments and other types of assessments to ensure the safety of survivors. Someone using a DIY kit does not have access to those kinds of assessments, which can be very critical and life-saving for some survivors. Additional differences is that in Maryland, sexual assault forensic exams where somebody has evidence collected, they have access to free follow-up care for between 90 and 180 days. Right now, it's 90 days, but we're looking to expand that to 180 days, as that is when a survivor should be having regular testing for possible contraction of HIV up to 180 days after an assault. So we are advocating for that. Safes conducted in a hospital also allow for advocate or support presence. DIY kits do not necessarily in the official capacity. Somebody may have somebody with them if they're doing it at home, but it may not be that trained, certified advocate that works at a local rape crisis center. Also, safes that have evidence collected during them is generally that evidence or safe collected DNA. So DNA that is collected during a safe provided at a hospital is often eligible to go into the combined DNA index system that's overseen by the FBI. So that's CODIS. CODIS allows us to connect crimes that were committed by the same perpetrator with each other. It allows us to identify stranger rapists if they have a violent past. It allows us to see if somebody is a violent serial offender. DIY kit DNA is not eligible for CODIS. Some companies may say or claim that it is, or that it could be. As it stands right now, that any DNA that somebody has obtained through a DIY kit would not be eligible for entry into CODIS. So it would be very limiting if somebody is looking for identifying a perpetrator in a criminal investigation, and it would also impact admissibility. So evidence that is collected during an official safe is generally recognized as admissible in a court of law. DIY kit collected evidence is not. Not much is known if there's any cases where somebody has tried to have this type of evidence admitted into court, but generally speaking, it is highly unlikely that any DNA evidence obtained through the use of a DIY kit would be admissible in court. So in general, the use of self-administered kits. MCASA really supports survivors accessing forensic medical care in a manner that they are comfortable with and is accessible to them. However, DIY kits are really not recommended right now and should not be the preferred option of care. And if somebody is looking into using a DIY kit, they should really be informed about its limitations. Again, if somebody's ultimate goal is possible identification of a perpetrator, criminal prosecution, etc., somebody should be informed that this option is going to very much limit that possibility for them. So that if they would prefer to go with the official safe provided at a hospital, they understand that that opens doors for them in terms of criminal prosecution and investigation. Once recommendations are issued by the SAKI committee, MCASA will share the information with Maryland service providers. So we will be sure to let everyone we're connected with know through our listservs, our website, college consortium, working with Stephanie to inform all of colleges and universities that the recommendations have been issued regardless of what they say. And right now that recommendation could range from including warnings on any kits that are available to banning them completely. Right now, there's no decisions that have been made. So one thing that we can do as service providers is try and reduce barriers to sexual assault forensic exams. Again, I've noted that SAFEs are not necessarily easily accessible to all survivors and not necessarily in all counties or jurisdictions. There are many challenges and barriers that survivors may face, like transportation. For example, if they reside in a county that doesn't have a SAFE program and they would have to travel an hour to another jurisdiction to receive a SAFE, they may have to work out transportation, which could be a time commitment. Survivors may also feel that the details of their assault, it may be concerning to them to report that to a nurse. And if they're unaware that they have an anonymous option to receive a sexual assault forensic exam, it may prevent them from seeking that care. So somebody like a student who may think, well, I was drinking when I was assaulted, I'm underage, am I going to get in trouble for that? If we properly educate survivors, especially students, that detail is not the most critical detail, law enforcement is going to be most interested in investigating the sexual assault. And if they're still concerned, they can choose that anonymous exam option. And that's, again, going to be related to lack of knowledge. If our students and survivors in general don't know that these exams are free, if they have that evidence collected and they don't have to report to police, they may be less concerned versus if a student survivor is still on their parents' insurance and they are under the impression their insurance charged and their parents would find out. So making sure our student populations are educated on the anonymous options, the medical care, the follow-up, the cost, etc., is very critical. And it may actually deter people from using something like a DIY kit and getting a SAFE from a local SAFE program. So there are a couple important takeaways I want to note for these self-administered kits. And some of you may have been in communication or received outreach from a commercial company that is looking to have their kits available and used in Maryland. So we just want to make sure there's some correct information out there. That information being that self-administered kits are not, quote unquote, authorized for use in Maryland. And the state will not be paying for these kits to be used, and they will not be provided by the state at public locations like colleges or hospitals or health departments. If that were to be the case, that would be the individual agency or campus's decision. The state SAKI committee is still in the process of reviewing information and developing recommendations and guidance on the DIY kits. And as part of that, the committee is also looking at how to support an increase in forensic nurse examiner workforce to support SAFE program development and 24/7 coverage within our jurisdictions, and just making sure everyone is aware of what resources are available to them. If a commercial company contacts you or your agency, just make sure you know what the legislation says. Stephanie Erdis, our associate director, is going to put in a link to a letter that was written by Attorney General Anthony Brown that highlights a lot of the same misinformation and takeaways that we just went over. But if you would like to share that letter with any of your other service providers or colleagues or anyone that you may fear is considering the use of a DIY kit, please feel free to share that with anyone you think is relevant. And Stephanie, I want to note that I think a few slides were missed. Do you want me to see if I can go back and find them?
Yes, please. I see one that was missed, which is the slide regarding law enforcement's reasons for choosing not to test a SAKE kit. And so I
Yeah.
think that will answer one of the questions in the chat. First, I do want to address the question in the chat about the statute of limitations. So for a civil suit, there's a 1-year statute of limitations for an assault and 3-year statute of limitations for battery. And then for criminal cases, if it's a felony, there is no statute of limitations. So you could seek charges for those crimes at any time, even if it's years and years later. If it's a misdemeanor crime, then the statute of limitations is 1 year. Okay, and then I see we have the slide up regarding the testing of SAKEs. So in Maryland, over 7,000 untested kits have been identified. And due to this, in 2019, the General Assembly passed legislation that went into effect January 1st, 2020. And that legislation requires that all kits must be submitted for testing unless one of 4 exemptions is met. So Maryland Criminal Procedure 11-926 outlines what these 4 exemptions are. And just to make sure I'm really clear, law enforcement only has to meet one of these 4. So the first one is that there is clear evidence disproving the allegation of sexual assault. So often this exemption is referred to as an unfounded false. So law enforcement must have clear evidence that indicates a report was false. They can't just have a belief or a hunch that it wasn't true. So the evidence of a false allegation must be obtained through a thorough investigation. So if law enforcement is just seeing inconsistent statements from a survivor, or if the survivor is refusing to cooperate with the investigation, that is not enough to classify a case as false, and not enough for law enforcement to choose not to go forward with the investigation. The second exemption to testing is that the facts alleged by the survivor, if true, could not be interpreted to violate these provisions listed here of the criminal law article. So it means that by law, the facts that are alleged are not one of the sexual misconduct crimes in the state of Maryland. The third exemption is that the victim from whom the evidence was collected declines to give consent for analysis. So this encompasses all of the anonymous exams, as well as any case where a survivor may no longer wish to pursue a criminal investigation. Survivors can make this decision for a variety of reasons, such as their safety or their well-being. And it's important to note that when a survivor requests that an investigation stop, law enforcement agencies need to explicitly ask the survivor what they would like to happen to their kit and whether or not they would like it to be tested. And the fourth and final exemption to testing these kits is that the suspect's profile has been collected for entry as a convicted offender for a qualifying offense in the CODIS system that's maintained by the FBI. And the suspect has pleaded guilty to the offense that led to this sexual assault evidence kit. So if both of those items are met, then law enforcement can decline to test the SAKE kit. And then Laura, did you see any others that we missed?
No, I think that was the only one. So hopefully that answers the question. Somebody asked about why law enforcement may not test a kit. This testing criteria really limits that discretion on when a kit will be tested or not. And again, if a survivor, just to recap, Stephanie, if a survivor disagrees with law enforcement's decision not to test a kit, even if they're stating that it meets one of these exemptions, they can request a local SART review of that decision, who will look at the case and the circumstances and facts of the case and compare it to these testing criteria. So I think that's it. I'm going to apologize because I'm going to fly through these slides to get to the end, so I hope it doesn't hurt anyone's eyes, but our contact information, it's not working for me. Our contact information will be posted on the screen if you have any questions after the presentation. And I believe I saw in the chat that the slides will be available to those of you that attended today's presentation. I don't know, are there any other questions? There's no other questions. I think we can wrap up today's presentation. Thank you all for attending. Please let us know if you have any issues with do-it-yourself kits, or are there any concerns about access to these kits amongst your students on college campuses. Please feel free to reach out to us. We'll be happy to provide more information and would love to be aware of any of those situations. And I did see a question in the chat about this being scheduled to 3 or 3:15. It was scheduled to 3:15, but that was to give us a little room for any questions anyone may have. So that's kind of what that 3:15 buffer period was related to. Somebody else asked for us to share our contact information. I put that back up on the screen.
So please feel free for the next couple of minutes to add any questions to the Q&A or the chat. If you have questions that you think of later for Laura or Stephanie, you have their contact information right here. Feel free to email them. This is kind of an evolution of something that we've been working with over the last couple of months, and we will continue to work with. So look for updates as well for DIY kits. Laura gave you a little bit of a timeline, so we will have more information coming this fall. We will end this webinar now. We're so glad that you were able to join us. Just want to end with a couple of notes. This is the first of 6 webinars for the virtual campus training series. We will have one in October and one in November of this year, and then we'll have 3 more in the spring of 2024 as we round out that academic year. So stay tuned in your email for updates and registration links on those. And you will get a follow-up email with both the recording and the slides for this program, including the slide that has this contact information on it. So we'll stick around for just a couple minutes in case anybody else has questions. Please fill out those evaluations that you see in the chat. And enjoy the rest of your afternoon. Thank you for joining us today.